Good afternoon, everyone. Welcome to our one-hour webinar on special needs planning. We're very happy to be here today, happy that you could join us to talk about what is an extraordinarily important topic, and that is planning for those special people in our lives that have the need for government benefits, the need for resources, and the need for a coordination of planning and care. We're going to walk you through the planning process, the documents that are available in this planning realm, and some of the new changes that have occurred. So our agenda for today, we'll get to in a moment. We are Pierro, Connor, and Strauss. Our law firm has our main offices in Albany and New York City. And we practice in the areas of estate planning, elder law, special needs planning, and business organizational planning. We are focused and niched in these areas. We don't do other types of law. And so we're able to hopefully bring a depth to the practice. And we do believe very strongly in education. So we do a number of these types of webinars. You can always access our past webinars on our website, which Beth just mentioned, and that is pierrolaw.com. With me in today's presentation, I'd like to introduce first my partner in the New York City office, and that is Peter Strauss. And Peter is one of the early pioneers of elder law and special needs planning. And he's been working in this area for a number of years. I won't give him away, but good afternoon, Peter. Welcome to the webinar.
Good afternoon, Lou, and to all of our attendees today. Welcome.
And one of the newest attorneys at Pierro, Connor, and Strauss. We're very happy and pleased to have her as part of our team. She's joined us in, again, the New York City office. She comes to us with a number of years, I think 22 or 23 years of experience in the planning for estate planning, elder law, special needs planning, and that is Lorese Phillips. Good afternoon, Lorese. You're muted, Lorese, if you want to unmute your microphone.
Good afternoon, Lou and Peter and everyone attending.
So our agenda for today, special needs basics. We'll go through some of the things that you need to know in terms of the basic rules applicable to individuals with special needs and the benefits programs that they rely upon, the planning techniques, how we plan to keep those benefits while making resources available to enhance the lives and provide for the needs of those individuals, the federal benefits programs. We're going to talk a little bit about some Medicaid rule changes that are upcoming, which are very, very important to know about. And the effective date for many of the rule changes is October 1st. Then we'll talk about designing trusts, in particular for individuals with special needs and the various types of trusts, and some of the innovation that we've tried to bring to the design of those special needs trusts. Some new rules that apply to retirement accounts. So if you're planning for an individual with special needs and the asset that you want to leave to them is an IRA, 401k, or other type of retirement plan, you need to know what the Secure Act brought us in the way of rule changes on January 1st of this year. We'll talk about that, and then what your next step should be in the planning process. We'd like to take a brief poll. So this is an interactive presentation. We're going to take 4 polls throughout the presentation, and we just want to get a feel for who's in the audience and who's listening so we can tailor our presentation to you. So are you a caregiver for someone with special needs? Are you a special needs individual, have a disability? Are you a professional who works with people with special needs? If you would respond by clicking on one of those, or 2 of those if you're more than one. We'll give you a few more seconds. Okay, pencils down. Let's see our results. So we have a number of caregivers, and we have a significant number of people who are working professionally with people who have special needs. That gives us a little indication. So we'll try to keep it broad enough for everyone, but give some insights for those professionals who are working in the special needs area as well. So with that, I'd like to turn it over to my partner, Peter Strauss, to talk about special needs planning basics.
So good morning again, and I think the poll is very interesting. 31% of you who are tuned in today are caregivers, and then of course the professionals are working with caregivers, and those of you who are persons with a disability are also vitally interested in this. So for the caregivers and the advisors to caregivers, I have to say you are probably burdened with many serious issues, and you're handling this, and we hope today will help you. But also the basis of part of what we want to talk about today is that none of us are going to be here forever. And the question is, what will be the plan when you are not able to be the caregiver, when you will not be in charge, when you will not be able to do what you're doing now? So special needs planning deals with that. And for those who are persons with disabilities, you also need to know some of the things we want to deal with today. And planning is to deal with those issues. We want to create and implement a plan for the person with disabilities so that the finest and services can be provided and appropriate government benefits can be tapped. And in doing so, and this is a theme that you're going to hear throughout this hour, we want the person with the disability to participate in the planning and decision-making to the maximum extent possible. You have rights, and you are the person about whom these issues deal, and we want you to participate. Sometimes that's not possible, but we want to incorporate your thinking as much as we can. So that tells us to what the goal, brings us to what the goals are. And the goal is to create this plan to balance your needs as a person with a disability with those of your family, to communicate the plan that we develop working with you and your other professional advisors, to communicate it to all the interested parties and the parties who may be the ones who will be in charge later on. And we want to make sure that this plan is flexible and it can change and not be locked into a set of rules that we develop now. And we hope that this will give you peace of mind and your caregivers peace of mind. Now, what's most critical here is to focus on what happens if you don't plan ahead. And if you don't plan ahead, if you don't have the proper trust in place, if you're not obtaining the entitlements to which the person with disabilities is entitled to, the courts will intervene. You will, in a sense, be out of control because a guardianship may be necessary either through surrogates court, Article 17A guardianships, or Article 81 in the Supreme Court. And there may be someone that you would not choose who will be named the person who will be in charge of the person for whom you're now providing care. So the other problem of not planning is if you as the caregiver die and there are assets that pass outright to an individual who has a disability, that may disrupt those benefits because the person with the disability may now have assets that will make her or him ineligible for the benefits that they've been receiving. So this could be a real disaster. Also, if you don't plan ahead, and you'll hear a little bit more about this later, if a will is the document that creates a supplemental needs trust, there may be a delay and those benefits may not be flowing from private resources. And finally, I just want to say this, if you don't plan ahead and we don't look at all the options for financing long-term care, the money may run out and then your beneficiary may be counting on only government benefits, which may not be adequate. So we want to preserve private assets to the best as possible. So these are sort of the background pieces for this. And we're going to now move to Lorese, who will talk about what some of the planning steps need to entail.
Thank you, Peter. So what you will want to do and what you need to do is create a personal care plan. If you're the parent of a disabled child or taking care, caretaker of a person with disabilities, or you're the person with disabilities, you still need a personal care plan. The care plan will involve a working knowledge of a broad range of issues, including government benefits and eligibility rules, trust and estate law, estate gift and income tax rules, guardianship law, as Peter mentioned, basic financial planning, and knowledge of available resources, including social, vocational, and housing resources, some of which are only funded through government-funded programs. Now, this is a very complicated list, then we don't expect all the lay people that are attending here to be knowledgeable about all these things. So you will need to put together a team of trusted advisors to assist you. Part of the care plan, as I just mentioned, is that you will need an estate plan. Particularly if you are the caretaker of a disabled person, then you will need to give consideration to how will your estate be divided amongst your beneficiaries. Do you have a will and trust in place? Does your will or living trust have a properly drafted supplemental needs trust for the person with disabilities? Will your funds be exhausted either addressing the caretaker's needs or after your death during the lifetime of your child with disabilities? These are all questions you need to consider in formulating your estate plan. You need to also think about, will the appointment of a guardian be necessary, and who will be that guardian for the child with disabilities if such a guardian is needed? And you also want to be knowledgeable about what federal and state benefits programs can support the person with disabilities so that your estate plan can use those government supports and supplement and complement what the government will provide. You will want to have an estate plan that protects your assets during your lifetime, so you will also be able to provide for your child after death. Part of your care plan, you will also want a financial plan that involves enhancement of your wealth and making sure there's enough to, again, leave to your children to meet your goals and to take care of your disabled child. And you'll want to put together a team of the appropriate people to help you, not only during your life, but after your life is over and that you're not able to be the primary caretaker. The fundamentals of special needs plannings. Almost all care plans involving a person with disabilities include a supplemental needs trust, which is also known as a special needs trust. Supplemental needs trusts, or SNTs, as I might say, provide a supplemental source of funds for a person with disabilities that supplement need-based government benefits such as supplemental security income and Medicaid. Because of certain legal limitations on these trusts, individuals can remain eligible for such government benefits. And again, the idea is for your personal family's wealth to supplement what the government will provide. And this you will do through an estate plan and even during your lifetime, depending on the circumstances. Government benefits that are available to persons with disabilities are SSI and Medicaid, and they provide a basic level of support for food, clothing, shelter, medical care, long-term chronic care for the person with disabilities. But again, it's very basic, and the SNT can pay for the gaps. The SNT can pay for recreational activities, additional medical treatment, individualized therapy, and specialized medical equipment. We're also going to be talking about this afternoon federal benefits that are need-based and non-need-based. And just quickly to review what those are, federal benefits that are not need-based, are SSI, Supplemental Security Income. You can also get, and after 2 years of being on Supplemental Security Income, you can qualify for Medicare, which is terrific, excellent medical insurance, but it does not cover the cost of long-term care needs. Another federal benefit that's non-need-based is disabled child, adult child benefit under the Social Security Administration based on your work record as a caretaker. Federal benefits based on need are SSI, which is Supplemental Security Income to persons with low income and limited resources who are older than 65 or blind or disabled. Your child, if younger than 18, can qualify if they have a medical condition or combination of conditions that meets Social Security's definition of disability for children, and if his or her income and resources fall within the eligibility limits. So with SSI, the child would receive $783 a month from the federal government plus a state supplement. The child's not allowed to have any more than $2,000 in resources. So important in most states, if you get SSI, Medicaid comes automatically, and Medicaid is the comprehensive medical insurance program and has a long-term care component. For Medicaid, if you're working, your income cannot be over $895 a month, or in New York, you would have to spend down that excess income or use a certain kind of trust that can protect that excess income. So it's not fatal to have that much income, but that's the income limit in New York. And you should not have resources over 15,750, because then you will be considered to have excess resources. And then you'd have to spend down those excess resources on medical expenses before becoming eligible. However, there are certain exempt resources that you are allowed to have and still qualify for Medicaid. And those would be a home up to a certain limit, a car, burial fund, tangible personal property, and life insurance if it doesn't have cash value over 15,750. So there are the basics.
So
But
Lorese,
now,
as we get to talking about the design of special needs trusts, and Peter, it's very, very important to identify what benefits the person is receiving now and what benefits they may be entitled to in the future. The hardest trust to draft and administer is one for an individual on SSI. And that's because of the $2,000 asset limit outside the trust, but also the in-kind rules, where if you are paying for certain things from the trust, they will diminish the benefit that the beneficiary is entitled to, that SSI income benefit.
Correct, and we'll talk a little bit later about what those excess income rules are. And for Medicaid purposes, we can protect the excess income, that number of 8, I think it was 98 that Lorese mentioned in a prior discussion. If it's $1,000 over, in theory, you're supposed to spend that down on your care, but by using a pool trust, and we'll come back to that later, you can protect that income. And if supplemental needs trusts are created and that supplemental needs trust pays for the rent of the person with the disability, the SSI benefit will be reduced by 1/3. And I think the same would be true about food as well. So we need to be careful about that. And probably if there are funds in the supplemental needs trust, that loss of some part of the SSI benefit may not be the most serious issue we need to face, but people need to understand that that is a result that may happen.
And Lorese, I've had clients who have actually backed up, been on SSI, but then became eligible for a different type of Social Security benefit through a parent perhaps, and then converted. And so that takes them out of the SSI rules, gives them a higher income usually, and allows you a great deal more flexibility in the administration of the trust. Have you ever experienced that, either of you?
I have. I was working with a family with a young son who was on the autism spectrum. And when the father started collecting his Social Security, he noticed that his son went up from collecting the SSI benefit, which is very small and subject to all these regulations, to suddenly getting so much more under his Social Security. And that's called disabled adult child. The child must have the medical disability resulting in an inability to work prior to the age of 22. And the other wonderful component of getting that disabled adult child benefit is that then after 2 years, the child qualifies for Medicare. So that just, again, helps to provide the basic level of care in terms of the healthcare and gives a little bit more income every month.
Absolutely.
And Medicare benefits may be much more desirable than the Medicaid benefits. More doctors will accept it. The reimbursement rates are a little higher, but people need to know that many, many doctors are now no longer participating in the Medicare program. So that benefit may not exist for everybody, but the conversion from SSI, if a parent dies or starts taking their benefits, may be a very, very important tool that our audience needs to know about.
Mm-hmm.
And so the initial assessment of the case by the attorney, the financial professional, the care professional, will involve almost always a review of the award letter. You want to make sure, because a lot of people don't know the exact structure of their benefits. Most clients, I think, that come to us, I ask, is it SSI? Is it SSDI? They don't really have a firm grasp on where the funds are coming from. So it's important to get the original document. What did Social Security Administration provide with that award? And they will spell out the breakdown. Some people get both, an SSDI and SSI award. So you have to know what that benefit is up front and know that it is fluid. It can change over time. So you have to keep looking and exploring what benefits are available. And I think the best of all worlds, Peter, is a dual eligible who has Medicare as the primary and Medicaid as the backup, so that you can have more choice and flexibility. Once you're disabled for 2 years and you have Medicare as your primary, you can still have Medicaid as the backup, because as we know, there are many things that Medicare does not pay for in terms of actual hands-on care. So dual eligible.
Right, and critically for this audience, it's the long-term care, because Medicare, except for some very small benefits post-hospitalization, is not going to be helpful. So the Medicaid needs to be kept in place. So don't assume that just because you're going to get Medicare that you don't have to worry about the person with disabilities acquiring assets at that point. We still don't want that to happen.
Exactly. So every case is unique. Every family situation is unique, and you have to explore all of the benefits that they're entitled to and what they're receiving currently. And as we go through the rest of the program, we'll talk about designing the plan around that individual and their needs. I mentioned that there are changes upcoming in the Medicaid rules in New York State. This is part of the budget process from last April, April 1, the budget passed, and it included a number of cuts to Medicaid home care. One of those was a change in eligibility rules to impose a look-back period. Up until now, we've had no look-back. We could do transfers and qualify for Medicaid home care immediately. As of October 1, there will be imposed a 30-month look-back. That's going to be phased in, so it won't be 30 months on day one. It's going to phase in for the next 30 months. But now we have transfer penalties applicable to the applications for home care benefits. And we also have changes in the medical eligibility rules. Now, instead of 2 activities of daily living, you'll need to have 3, and it be in need of 3 ADLs, substantial assistance. There are also changes in the primary doctor not being able to weigh in on the case. They're going to have independent physicians doing the examinations, independent assessors who are going to determine the number of hours of care that an individual is eligible for. We're going to talk a little bit about it right at the very end, but we have a webinar coming up focusing on these rules on September 1st. It's at 12 to 1 and 6 to 7 in the evening. So if you want to get the latest information on September 1, the implementation comes October 1, so it'll be 30 days out. On September 1, join us for that webinar, 12 to 1, 6 to 7, and we'll be talking about the details. There have been a number of legislative proposals to try to fix some of the rules to make them more applicable. And we'll have the latest guidance from the New York State Department of Health and the New York State Legislature for that webinar. So with that, let's talk about transferring assets and gifting assets. A lot of families come in and they say, well, I have a child with a disability, they get SSI, they get Medicaid, so I can't give them anything. And many people get advice from a lot of different places, and one of the pieces of advice I've heard 1,000 times if I've heard it once is, we'll just give it to our other children and they'll take care of their sibling. Peter, Lorese, do you hear this often?
Very often. I hear bad ideas repeated very often.
Yeah.
But that other sibling or those other siblings have what we call beneficiary risk. What if they die? What if they become disabled? What if they have a divorce and the assets are in their name and now half the assets are going into the divorce proceeding? What if they don't do their own planning and have a bankruptcy? All of those risks can befall that family if they don't do the planning properly. So instead, what we're going to talk about is the use of, as Lorese said, supplemental needs trusts. These trusts are constructed to provide for individuals who are disabled. And in order to take advantage of the provisions, you have to have a determined disability. But the legal benefits that you are entitled to, all of those rich benefits that we were talking about, income from SSI and medical care through Medicaid, all of those stay available, even though the assets for the individual are held in this supplemental needs trust. So we're going to talk about the design, the details, the craftsmanship that can be brought to bear in creating a special needs trust or supplemental needs trust for an individual with a disability. Is it a cognitive disability or a physical disability? That will have a lot to say about how the trust is administered. They are people with a disability, but they also have ability. Sometimes we refer to them as other able individuals. So as Peter said, we want to construct a care plan and a trust plan that merge to give this beneficiary as much ability to participate in their own plan. I've done a lot of work here in Albany with disability advocacy groups, and the motto is nothing about me without me. And that applies to special needs planning as well. If we do it properly, it's going to protect the assets of the individual. And Peter, there are several different varieties here. Why don't you walk us through them?
Correct. So whether you call it special or supplemental, there are really three types of trusts that you're going to be dealing with here. And we don't have a lot of time, so I'm going to do this fairly quickly. A trust, when a person with a disability has resources, assets, those resources can be put into a trust that person creates. They create their own supplemental or special needs trust, and that's referred to generally in the trade as a first party because you're the only one involved. If it is the funds or resources of a parent or some other relative, could be a grandparent, it could be a sibling, it could be the good neighbor next door. Those funds go into a special needs trust that are treated and designed very differently when it is not the assets of the person with disabilities, and we call that a third-party trust. We should do a poll about what happened to the second-party trust, but I've never gotten a good answer. So I'm going to skip to the next. Pool trust, that's the one I mentioned earlier, and we'll come back to that you can protect excess income. So these trusts, these supplemental needs trusts, are designed so that the discretion about spending the money is in the hands of an independent trustee. Could be a parent. It just can't be the person with disabilities. And secondly, the design has to make sure that distributions from the trust are not made to the person with the disability, because that would be extra income that in some states might make them ineligible, not in New York, but it's an excess income that has to be dealt with through the use of a pooled trust. So you don't want to give cash grants every month. You don't want to have an allowance, maybe a few bucks for spending money, but nothing significant. So for purposes of Medicaid, the benefit, the money that's expended on providing in-kind resources, you pay the rent, you pay for the food, you pay for transportation, that money won't be counted to reduce the benefits in New York. In-kind payments are not counted. So we need to keep those rules. But and finally, the design of the trust, the wording becomes very important. It can't be treated as what the law calls a support trust. So it has to be totally discretionary in the hands of the trustee, and not saying things like, this is for the health, welfare, and support of the person with a disability. It's just in the sole and absolute discretion of the trustee as to whether it's an appropriate discretion. So then the question is, who are all these players? Who's the trustee, et cetera? Well, the creator of the trust, sometimes called a settlor or the grantor, is the person who establishes the trust. In a first-party trust, it's the person with disabilities. In a third-party trust, it's the parent, grandparent, sibling, et cetera, who is establishing this trust. Again, the trustee controls. The trustee is a fiduciary and is guided by certain legal and ethical issues as to what kind of a role he or she plays, and they got to do their job right. Now, also additional parties to the SNT, although not necessarily having any control, are a patient advocate, a care manager, a not-for-profit organization that might play those roles, or something we call a trust protector. a very, very independent person who can perhaps modify the trust under certain circumstances. Again, I've touched on this concept of a first-party trust. These are trusts that can be created for the benefit of a person with disabilities who is under 65 years of age. A self-settled first-party supplemental needs trust cannot be created for a person who is beyond 65. So this planning has to be done at an appropriate time. And there are persons who develop disabilities later on. Diseases like Alzheimer's disease or Parkinson's disease, ALS, really don't happen usually for younger persons. So it may be that the onset may be in the 50s or even early 60s of a person who may have assets, and those assets can be put in a self-settled supplemental needs trust, but they have to do it before they become 65.
Peter, very often the circumstances that arise, a disabled individual either becomes disabled because of an accident or a malpractice, medical malpractice, or they inherit money that someone leaves to them directly and outright. So they get lump sums of money. And the question then becomes, how do they preserve their benefits and stay on and keep use of those funds without having to spend them down for SSI to $2,000, Medicaid $15,750. So there are a lot of situations that arise where even a person who's disabled from birth and never worked gets a windfall, gets a lump sum of money and needs to protect it. And this is the kind of trust that they're going to use.
Correct. And they have to do it before 65. Now, there's one other important point here that I want to make is if you're over 65, you can create what we call a Medicaid Asset Protection Trust. But the problem with that trust is that the trustee cannot access directly the principal of the trust, whereas a supplemental needs trust that's self-settled, your own funds, this windfall you might get at age 61, if you get it into your self-settled SNT, the trustee of that trust can use the income of the trust and the principal for your benefit. So it's a very powerful tool. How the Congress ever passed it 25 years ago, this exception to normal rules of Medicaid, was an unbelievable thing that we as elder law attorneys and trust and estate attorneys back then fought for, and we got it. And it was really remarkable, and it continues to be a remarkable and powerful benefit for persons with disabilities.
But who can create the trust, Peter, used to present somewhat of a quandary. And I remember hearing you speak in 1993 when the Omnibus Budget Reconciliation Act of 1993 passed, which included the rules for first-party special needs trusts and many of our Medicaid trust rules. And you called it the draftsman by the four horsemen of the apocalypse.
Correct.
Because they restricted people who were otherwise very mentally competent, perhaps physically disabled. They prohibited them from creating their own trust.
Right. At that time, in the original law, the trust could only be created by a parent, a grandparent, a court-appointed guardian, or the court itself, but not the person with the disability. And I always ask members of Congress, because I've spoken at a lot of hearings, why they did that. And frankly, I came to the conclusion that the members of Congress who wrote this law thought that everyone who was disabled or had a disability was cognitively disabled as well as physically disabled. So they had this broad brush. And it was only 2 years ago that we got the Congress to change the law. And now the person who has the disability may create their own first-party supplemental needs trust.
Yeah. And one of our colleagues, Michael Amoruso, was the president of the National Academy of Elder Law Attorneys at the time. And he actually has his picture on his website with Joe Biden when that law was signed. He was there in Washington. And Michael has his own disability. He's legally blind and a fully functional, tremendously capable special needs and elder law attorney. So he's the one that gave me the term.
Before I turn it over to you to talk about the third-party trust, two important points that need to be said. One, I think you all know by now that the resources, assets in your first-party supplemental needs trust are not countable in determining your Medicaid eligibility. So the $15,780 rule doesn't apply. You can have an unlimited amount of money in your first-party supplemental needs trust. There's one little kicker here, that when the beneficiary of a first-party supplemental needs trust dies, Medicaid must be repaid the dollars that it has expended for the benefit of you, the person with disabilities. You know what? It's a free loan of important medical benefits for your lifetime. And it's not unfair that that rule exists. Maybe we can get some modification of it in the future, but right now we've got other important fish to fry. So Lou, why don't you pick up and talk about the third-party SNT and how it differs from this that I've just discussed.
Thanks, Peter. I just want to point out one thing. Creating the trust before 65 is important, but as is funding the trust, because even if you have it in existence prior to 65, you can't fund it any further than that. The other thing, the pool trust that you're going to talk about later, Peter, does remain available for income for Medicaid beneficiaries. So the pool trust can be used by people over 65 for income purposes under New York's Medicaid program. So just want to point those out. You're going to cover that more in detail. So,
correct. So long as you're living in the community, but we'll get to
correct.
That later.
I've worked with a lot of groups, parental groups that are planning, the NAMI, the National Alliance for the Mentally Ill, a number of other parental groups. You have the Autism Society. And for them, planning for their child is the centerpiece of their own estate plan. How do you provide for that child, protect that child? And in some cases, you have grandparents that leave money to children or other people, and they leave it outright. And as we said, if people get it outright, they have to put it into the first-party SNT, but that's not the best vehicle for you. And the courts in New York have given tremendous credence to special needs trust planning for other individuals, including children. I had a special needs trust in part of my estate plan for my mom who had Alzheimer's, and I was providing her with support. So I carved out a piece, if I predeceased her, I carved out a piece for my mother. Could be anyone, doesn't have to be a child. But there's a case in New York, matter of Escher, that carved this out from a legal perspective and gave us the underpinnings. And the parents of children with disabilities took that one step further to the legislature of the state of New York, and they enacted a law where there's actually a codified in the body of law of the Estates, Powers, and Trusts Law 7-1.12, EPTL 7-1.12, that actually lays out a safe harbor special needs trust. And that's a phenomenal tool. You can simply use that trust and you're going to get all of the benefits without that payback provision. And that's a major distinction. The money can go in trust for the child with a disability, and upon their passing, come back to the other children and their families intact without having to pay back the state for the Medicaid that's already provided. So in drafting the third-party special needs trust, we have unlimited flexibility. The trust under over 93, the first-party trust, you're limited. Third-party trust, creating it for that child, we've drafted them in 1,000 different ways for 1,000 different beneficiaries and tailored the provisions to each situation. So again, the trust assets can be used as the trustee directs, and the trustee can use income and principal. They don't have to report or account to the government, the Department of Social Services. So it's private, it's flexible, and it's very powerful in supplementing SSI, Medicaid, the other benefits that the disabled beneficiary is going to be eligible for. Again, it's a discretionary trust, no payback. And when we go to design this, we want to make sure we're looking at who the family members are, who the trustees are, and the roles that we create in these trusts that are a bit different than some of the other trusts that you may see, and certainly the statutory trust, include trust protectors, someone who can actually modify the document, make changes to the trust over time, and protect the disabled beneficiary and watch over the trustee and make sure the trustee is doing the right job. You can have a committee inside of the trust that will determine what the appropriate distributions are. And maybe you want to have someone with benefits experience who knows Medicaid and SSI. You may want to have an attorney. You may want to have a financial advisor. They can be part of the committee along with the family members that can then determine what appropriate distributions are from the trust. So all of this goes into the craftsmanship, as I said, of the attorney drafter who's going to put that trust together and integrate all of the players to make this the most potent trust that you can, free of government intervention, usable by the disabled beneficiary, and payable then to other beneficiaries upon that individual's death. So the question becomes, go ahead, Peter.
And that lawyer really needs to talk to the parents to see if they have spoken with their parents, the grandparents, to make sure that the grandparents are not leaving money outright in their wills to the child with disabilities. And that may lead to creating a freestanding living
let's take our poll.
Supplemental Needs Trust now.
When we're doing estate planning, this applies regardless of the context, special needs planning or Medicaid planning, or just strictly estate planning for beneficiaries. Anytime you have to go through the court system, you're going to have delays, expenses, attorney's fees, court fees, and potential challenges in the context of a probate proceeding for a will. You certainly can do the supplemental needs trust in the will, but if the beneficiary is disabled, as you know, Peter and Lorese, the court is going to appoint another attorney called a guardian ad litem in that proceeding. And the guardian ad litem is going to have to do a full investigation of the entire proceeding and is then going to issue a report to the court. I've had cases in Queens and Brooklyn where that has delayed the probate by 6 months just to get the guardian ad litem's report before letters were issued. And Peter, you were mentioning earlier, this ties up the funds during that entire period.
Correct. And as we learned during the pandemic, since March 17th, the courts were closed, the surrogates court was closed. And I had a client who died and he had all the assets in his name and his spouse had just a few $1,000s in one account and could not access the deceased husband's assets for a long period of time because the surrogates court was closed. So having a will delay, maybe, hopefully not, future pandemics may happen. Who knows what may happen. So the living trust has continuity, as you'll see here, and you don't need to go to the court. And
So,
by the way, if you have the trust established under a will, you may have to go back to ask permission to buy a computer for a child with disabilities. You don't have to do that with a trust.
So then it brings us to a revocable trust versus a standalone special needs trust. The way we draft revocable trusts, they have a tremendous amount of power and precision in crafting benefits for a special needs child. So if you're a parent and you create the revocable trust, it's primarily for your benefit. You generally serve as the trustee, and if you're able, you take care of your disabled child. What if you become incapacitated? You have provisions drafted into the trust that appoint successor trustees, and you provide them with specific language allowing them to use your revocable trust as a special needs trust to support your disabled child. All the same provisions that you would get in a standalone trust. So the revocable trust can be drafted with a great deal of detail during lifetime for incapacity, and then it becomes the full-fledged special needs trust for the disabled individual upon the death of the primary grantor, and that's usually the parent. So the revocable trust is an excellent vehicle to create a special needs trust. The issue came up a minute ago about what if you have multiple grantors, many people, grandparents, aunts, uncles, who want to support a disabled individual. Then, Lorese, I think a standalone special needs trust may be the better vehicle.
Absolutely. When there are grandparents who want to contribute or aunts and uncles and they want to help support the disabled child, definitely to already have that trust set up, then they can just designate that trust as the beneficiary.
Now, we mentioned earlier about leaving assets to other family members. Lorese, just touch on that a little bit.
Well, as we've been talking, when you are formulating your estate plan, you will need to make decisions about how to leave your estate, your family's wealth to your beneficiaries. And again, if you're a caretaker or parent, you may have a disabled child and other children that you wish to benefit from your estate. At times, however, often parents want to make that decision or feel compelled to make that decision when they're executing their will or executing their estate planning documents. But often when there's a child with disabilities involved, there might be that child who cannot support themselves whatsoever and needs more resources. And there might be other children who are supporting themselves and are doing quite well. And the parent might be unsure, what should I do at this point? Or maybe the future needs of the child with disabilities is not clear, and they might have greater needs at some point in the future. So if the parent cannot make that decision or feels uncomfortable making the decision at the time they're executing their primary estate planning documents, we are working with families to allow them to sort of defer making that decision to a later time. You can do that through something called a power of appointment, which that's another flexible tool we put into our documents. But we can also do that by potentially appointing a trustee or a committee or other people. Again, if you're not able to make that decision, but you have trusted people in your circle that you feel can make the right decision concerning how much of your estate should your disabled child get, and again, that would go to a supplemental needs trust, then that's something we can also build in that flexibility. A lot of parents do worry about this. And a lot of times they say, you know, my son, he's fine, he's doing well, and he will actually take care of his disabled sister, not to worry that he'll think about himself first. So these are just options that we give to families.
So
go on.
When we start talking about designing it for the beneficiary, a lot of times, as we said, the beneficiary will have abilities, and they'll have fluctuating abilities. So we want to build in all of the protections, but we also want to empower that child to take the most significant role in the plan that they can. And it may be that they're bipolar, schizophrenic, they're on the spectrum, and it may be that medications will keep them in a position where they can do all of the things for themselves very well, but then at certain points in time, they may not be able to have that ability. So we are actually designing trusts. We call them empowerment trusts that allow us to put in place the ability for the child to participate meaningfully in the trust management, in the use of the trust funds, and to, at times when they may not need benefits, to be a full participant, but when they do need benefits, to have another trustee who can administer it for them. And again, when we're drafting third-party trusts, we can build that trust with tremendous flexibility and power to have those key people, the trustee, the trust protector, the distribution committee, functioning with the disabled individual so that that empowerment trust is there for them. And I deal a lot with NAMI parents, and they want to make sure that their children are motivated and have the greatest desire and maintain that motivation. And the empowerment trust is the vehicle that we've crafted for use in that realm. And this is a key issue. Who is going to be that trustee? Is there a family member who can handle it? Do you go outside of the family to a third party? And do you have a corporate or professional trustee or some combination of those? And Peter, this is an area where we spend a lot of time in discussion.
Correct. It may be the critical question here, because just think of all the power that we're giving to this trustee, and particularly when the parent is the initial trustee and dies. So we're getting short on time, so I can't spend a lot of time on this, but the subheading of this slide, I think, is the key to this. You want to look for the person whose judgment is going to be relied upon, and they need to have experience, but not necessarily experience in Medicaid law, not experience in legal terms. It's about judgment, the relationship with the beneficiary, and integrity, and that's what you should be striving for. And this is true also with your power of attorney and your healthcare proxy. Who's going to be the successor agent if you're not able to do it and your spouse has died? So these are critical questions that we need to discuss with a client in great depth.
And very often you're going to layer in a corporate trustee with
Correct.
that.
And you know, you may not meet the standards that they will accept because of the dollars involved. There are banks that will accept trusts of maybe $400,000 to $500,000 in New York, and some of them have some experience with dealing with persons with disabilities who are beneficiaries and may even have care managers on their staff. But there are fees involved, and you've got to make sure that they're going to be able to devote the time and attention that is necessary. But in the last resort, it may be an option that you need to explore.
So let's go back to the pool trust very briefly, Peter. We talked about these earlier. These can be a very tremendous resource when you don't have a trustee as well.
Correct. So in the case of there's excess income, if your Social Security and maybe your retirement fund now that you're drawing down, even if you're under 72, which is the new age, you're allowed to do that. And if you're disabled, there's no 10% penalty for early withdrawal. That income may total more than the allowable amount in New York. So rather than having to spend it down by paying the home care agency that excess income, you can put it into what's called a pool trust, which is a trust created and managed by a not-for-profit organization. I've written about 15 of these pool trusts in New York State. They work very well. You have a separate account in this master pool trust, and that trust, which you can use whether you're under 65 or over 65, so long as you're living at home and are getting Medicaid home care benefits, which are pretty generous in New York, notwithstanding cutbacks, that excess income can then be used not to pay for the vendor who sends in the Medicaid worker, but for your rent and your food and your transportation. So
Peter, they can also be used for assets.
Using the pool trust.
You can use them for assets for people under 65 as well, if
Correct.
you just have smaller amounts of money that you want supervision of. So non-trust assets, we have to make sure that we weave in. I'm going to skip over this slide, if I may, and talk about life insurance, because in special needs planning, Lorese, this becomes a major issue.
Life insurance can provide the family with the comfort of knowing that even if there are financial setbacks in the future, there will be a source of assets to fund the SNT. And as we've been saying all along, you not only need to establish the SNT, but you need to fund the SNT. And life insurance can designate the trust as the beneficiary. It can be immediately available to pay over to the trust, and therefore, again, there's not going to be any lag of time if the trust is established as a freestanding trust and not under a will. And it's a relatively low cost option for funding an SNT. There are numerous different kinds of life insurance. There's term life insurance, which is less expensive, but it's only for a limited term, which can be 5, 15, or 20 years. So with a family with modest means who want to opt for funding a trust with life insurance, this may be the way to go. However, you have a little bit more money and can pay the premiums. A whole life policy with a guaranteed death benefit and designating the trust as the beneficiary would definitely be preferred. There's also universal life, but sometimes premiums may fluctuate in universal life insurance.
We want to let our viewers know that we're going to run over by a few minutes, not a lot, but a few. We have a couple more topics that we absolutely want to cover. Thank you for the life insurance. Sorry to cut you off there, Lorese.
Okay.
But we're running down on time. You should know there was a significant law change in January of this year, 2020, called the Secure Act. And it brought in new rules for IRAs, 401ks, and retirement plans, which only allow the beneficiary of that plan to stretch over 10 years. It used to be that you could stretch over a lifetime. There are exceptions to the 10-year rule, one of them being a person with a disability, another being a person with chronic illness. So when you're planning for the child with a disability, they actually get the stretch of a lifetime. So they can stretch it out through a special needs trust over their lifetime. So in some cases, what we're doing actually is redirecting the funding of the estate plan to leave more of the retirement plan assets to the child with a disability who can maintain the favorable tax treatment of the stretch, and then leaving other assets to the other children who would have to commute that to a 10-year payment period. On our website, pierrolaw.com, you can go and view our webinar. We did a full webinar, again, on the Secure Act and planning for the Secure Act. We are structuring trusts to accommodate those benefits, and special needs children are ideal beneficiaries now for retirement accounts because they get the lifetime stretch. So, Lorese, another vehicle that's out there quickly is the ABLE account.
ABLE is Achieving a Better Life Experience. It's a new law that was enacted both over the course of 2014 and 2015. The purpose of the ABLE Act is to permit and encourage people with disabilities to save their own money in an account, including their own earned income can go into the ABLE account, and that account can go above the asset limit for means-tested benefits. It can't go way high over the asset limit, but it can go above the asset limit. It gives the person with disabilities autonomy, which they miss when there's only a third-party trust and they feel they need to ask the trustee to make expenditures. So it's a wonderful device to give the disabled person autonomy. It can be funded by other people beside the disabled person. And if it's funded by a third party for SSI purposes, the payments from the ABLE account do not reduce the in-kind support that we were talking about earlier. So that's an interesting fact and a way to not reduce the rent payments or the food, reduce the SSI for payments for rent and food if they're paid from an ABLE account. There are rules about establishing an ABLE account. Number one, you need to be disabled before the age of 26 years, and you must be entitled to SSI or SSDI or be blind, or as defined in the Social Security Act, or have a disability that's included in the Social Security Administration's list of compassionate allowances conditions, or there's other disabling conditions. And specifics, again, your annual contributions can be $15,000 a year, and an ABLE account, it's one beneficiary, it's one count per beneficiary is permitted. So that $15,000 a year cap is a cap. But if you're earning income and the disabled person wants to contribute it to the ABLE account, then they can contribute an additional $12,490. 529 college plans can be converted over and paid to an ABLE account, still subject to the caps. But the maximum account balance in 2020 for non-SSI recipients is $520,000 in New York. For SSI recipients, it's only $100,000. The disadvantages, as we have here, is the last bullet point. You don't really necessarily want to accumulate that $520,000 because there's a payback provision at the end of the disabled person's life. So there would be that payback before the assets are able to be distributed pursuant to their estate plan.
So there's certainly tremendously useful tools for the disabled individual's own funds to put into the ABLE account. But because of that payback provision, if you're a third party, a parent or a third party, you may want to limit the contributions because of the payback provision. Then you get back into your third party supplemental needs trust, Lorese.
The third party trust is much better because there's no limit on what you can put in and there's no payback. It's nice to have both. If you're the disabled person, they appreciate having both.
So next steps, how do you assemble the team to complete an entire special needs plan, have a special needs trust, the care plan that we mentioned earlier, put it all together with a financial plan. You want a consultation with a qualified special needs planning attorney, a financial advisor who is familiar, perhaps with the financial planning side, the life insurance side, the benefits side, how ABLE accounts fit into a financial plan, and then identify who the care manager is going to be. And many individuals with disabilities have a caseworker or a care manager already as part of their plan. If not, you may want to find someone who can participate in managing the care and the benefits that the individual is going to be receiving, and developing the plan, and then implementation and monitoring. As we said earlier, this plan is going to fluctuate over time. The needs and the abilities of the individual are going to fluctuate over time. And this is very state specific as well. In New York, we have a number of different programs. We have the Office of People with Developmental Disabilities, OPWDD. We have traumatic brain injury programs and TBI waiver programs. So there is a whole host of benefits in New York that many of those states don't have. So you need to shop and look locally. Where are you? Where are the resources in your community where the disabled individual lives? And make sure that you're tailoring the plan to that locality. And I want to remind you that October 1, we have the Medicaid changes, and on September 1, 12 to 1 and 6 to 7, we have a webinar that you'll be able to get the latest information on those Medicaid changes and the rollout of the changes as we get into the fourth quarter of this year. You can register on our website, which you will see there. And I think that's all we have time for. So I want to thank you for joining us today. Peter, Lorese, excellent presentations. Thank you both for participating today.
And
there
good
are
afternoon, everyone. Stay well.
If you want to email, that's a choice we didn't put up there, but if you want to email any of us, you can do so. There are email addresses. We'd be happy to respond to your personal questions or provide any information that we can. Thank you for joining us. Stay safe out there, and we hope to see you again very, very soon.
Stay well.